Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. This bill is set down for third reading forthwith.
Speaker.
Honourable Chris Finlayson.
Mr. Speaker, I move that the Video Surveillance Temporary Measures Bill be now read a third time. Mr. Speaker, I endorse what Mr. Hyde said. I think this bill is the result of political parties working together to find a solution to a problem. It's not the result of any one individual, it's not the result of any one party, it's the work of Parliament. The sequence of events leading to this third reading goes something like this. On 2 September, the Supreme Court gave its judgment in the Hamed case. It was suppressed. So applications needed to be made so that suppression orders could be varied. The decision to lift suppression on most of the judgment was finally issued on Thursday, 15 September, 3 weeks ago today. From that point, the government worked as fast as possible to find a solution to the problem. After a week of consultation by me when the House was in recess, a paper went to Cabinet on Monday, 26 September. The bill was introduced on 27 September and was reported back on 3 October. This afternoon, this Parliament will hopefully have solved the problem in the 3 weeks since the judgment was unsuppressed. Now, some have suggested the government has moved too fast to fix the problem. Well, I reject the submissions of some of those who said that this is the fastest lawmaker in the West. If members want an example of fast lawmaking, they need only look at the Westminster Parliament, which in July this year passed the Police Detention and Bail Act 2011. That bill was a legislative response to a problem presented by a court decision which changed a long-standing law concerning aspects of bail. The legislation reversed the judgment. It started and completed its Commons stages on Thursday, 7 July. It also had its first reading in the House of Lords on 7 July. It passed all these stages with the support of the Conservatives, Labour and the Liberal Democrats. Its effect was fully retrospective. It was not a temporary measure. So that's not what is happening here. This is a temporary measure, and I believe it is an example of Parliament working well, and I endorse the excellent editorial in the Herald today in that regard. From the time the judgment was unsuppressed, we have approached the situation with an open mind. I've tried to include the other political parties and groups in discussions. I acknowledge the assistance of the acting leader of the House, who gave me tremendous assistance to ensure that this bill could finally go to a select committee. Mr. Speaker, there are a number of members in this House who deserve credit for getting us to the point we are at this afternoon. First, I acknowledge my colleague Chester Borrows and thank him for his chairmanship of the committee. I also acknowledge Keith Locke and Te Ururoa Flavel, two members for whom I have enormous personal respect. Both Mr. Locke and Mr. Flavel have been troubled by this bill, and it's apparent their parties will not vote for it today. But they are both principled members of this House who have engaged in arguments on policy. Neither is interested in self-promotion, and I say to Mr. Locke that I shall miss his contribution in this House very much. I thank my colleague, the Honourable Peter Dunn, the member for Ohario. As it turns out, I met with him a number of times after the decision was released. I valued his advice and contribution, particularly on the sunset provisions. I also thank my colleague, the Honourable Rodney Hyde. He is another principled member of this House. From the outset, it was clear he had problems with the bill. He was prepared to support it to a select committee. His first reading speech, I thought, was very sincere and eloquent and rightly received a lot of praise. He played a very constructive role in the select committee, and I thank him for it. Like the Criminal Procedure Bill which passed the other day, the bill we are debating is testament to his tenacity and his intellectual input. And I want to acknowledge and endorse his generous comments about the Law Society and individual submitters like Professor Andrew Geddes of Otago University. I want to thank the Honourable David Parker, who in all my dealings with him on, for example, legislation concerning the foreshore and seabed and this sort of bill, shows himself to be entirely trustworthy. I think he's a genuine parliamentarian. At an early stage, he recognised the importance of the situation that faced the government and this Parliament. I believe that Mr Parker is a tough, principled opponent who always maintains personal confidences and observes parliamentary conventions. I think he's wrong on Section 7, but as he said, on the Section 7 report, that task was assigned to my colleague Kate Wilkinson, and the report concluded that Section 21 of the Bill of Rights Act was not engaged. So the bill we debate today is, to all intents and purposes, the bill was sent to the Select Committee. The difference is that certain elements of retrospectivity have been removed. I say elements because I don't see how the barring of appeals from people already convicted can be anything other than having a retrospective element, although I do say to Mr Locke, it could also be categorised as a legislative stay of proceedings for a period. And the Search and Surveillance Bill does not contain those provisions, and so it's going to have to be looked at again when the new Parliament reconvenes, and that may give him some comfort. So the important point is that this is not a new bill. As I emphasise, it's not a victory for any one political party. As I said, I agree with Mr Hyde. It is a bill which is a product of this Parliament. It's a credit to this House. Mr Speaker, I was pleased the evidence submitted supported the government's original contention that elements of the Search and Surveillance Bill could not be plucked out in some kind of hodgepodge fashion and rearranged into some new scheme. That idea was never going to fly. I think everyone now recognises that those complexities were too large. In conclusion, I want to thank all those officials for their hard work on the bill. I particularly acknowledge John Pike, General Counsel at Crown Law, and Elizabeth Grant of the Parliamentary Counsel Office for their hard work and effort on the bill. I believe that they are examples of the first-class public servants that we have, and it is right and proper that their efforts are recorded in Hansard. So as is now tolerably clear, and again I'm sure this will give Mr Locke some comfort, it is the task of the new Parliament, or will be the task of the new Parliament, to pass the search and surveillance legislation into law. Mr Speaker, I commend the bill to the House.
Question is that the motion be agreed to.
Mr Speaker.
Charles Chevelle.
Thank you, Mr